Mr. Rady.
My Lord, I was going to address the last topic in relation to issue 2.
Yes.
After having considered the cases and the facts relating to transfer and IBG, and that is
the third point on your second point.
Your third point on my second issue,
yep.
And that is Mr. Justice Field's judgment.
Yes.
The relevant passage in which can be found in the appendix at MS 132.
Yes, indeed. Thank you.
My Lord, relevant passage is paragraph 23. So the judge, having rejected the respondent's construction of clause 49, then goes on to apply it to the facts, and he does so as follows. IBG became Cargill's delegate of the obligation to unload under clause 8 by reason of the sale contract, including its demurrage provisions, and in my judgment for the purposes of clause 49 proviso, the failure to unload within the lay days was an act or omission or default that incurred in the course of performing the obligation to discharge as delegated to it by Cargill. It was Cargill, after all, who set in train the process of delegation and gave delegating parties a free hand to agree terms with delegates. I'm also of the view that IBG's failure to pay demurrage or to secure Transclear's claim occurred in the course of IBG's performance of IBG's delegated task, because IBG's obligation to carry out the process of unloading included the obligation to meet all necessary expenses to clear obstacles to performing that task that resulted from IBG's own failure to get on and unload the cargo. And my Lord, there are a number of difficulties with that analysis. The first difficulty is that the judge is no longer looking at the performance of the delegated obligation under clause 8. He is looking at acts which occur before the delegated obligation under clause 8 falls to be performed. That's the first difficulty. The second difficulty is that he, having rejected, as it were, the delegates by virtue of subletting, i.e. the wider construction of clause 49, he then seems to fall back on that in the application of it to the facts, because he says that it was Cargill who set in train the process of delegation and gave delegating parties a free hand to agree terms with delegates. So having defined clause 49 correctly as applying where the agent or delegate is performing an obligation of the charterer under the charter party and is only a delegate because of that performance, he then expands it to look at a notional process of delegation, which in fact does not take place because there is no delegation by Cargill to IBG. He then, thirdly, makes the error which is dealt with expressly in the case we looked at before the short adjournment, the Jalaguri. Namely, he regards the failure to secure Transclear's claim, i.e. to pay the demurrage or to secure Transclear's claim in respect of the demurrage, as being part of the obligation to carry out the process of unloading. In other words, he seems to regard that as a cost of unloading which the charterers had to perform under the charter party, and therefore the failure to meet that cost by IBG is a failure by the charterers to perform their obligation under the charter party. As was analysed in the Jalaguri on very similar facts, where the Port Authority required a guarantee to be put up to allow discharging to take place, the court analysed that correctly in our submission as not being anything to do with discharge or the costs of discharge or the physical process of discharging, but something entirely different. And so, my Lord, what Mr. Justice Field has done is to conflate, on the one hand, the performance of the charter party obligation, which looks at the de facto performance of that obligation by the charterer acting through the agency of another, with other contractual obligations which may surround that obligation. For example, may come in time in time before it, and may set out different requirements which are not found in the charter party, and run them all together. And in our submission, that is not a correct approach when one's looking at the performance of the charter party obligation. The question the judge should have asked himself was, at the time these acts were carried out, and looking at the acts themselves, were they done by Transclear and IBG when they were performing a charter party obligation. They were not, and indeed they could not be, because they had nothing to do with the charter party obligation, which was through whose agency the charterers were performing. So, my Lord, for those reasons, Mr. Justice Field's analysis is wrong, and the essential question is, in all these cases, just as in the Good Pal and the Mediolanum, is you identify the agent by asking, when you're looking at a de facto agent, or a de facto delegate, if we use that term in substitution for agent, you identify whether the person was performing an obligation of the charterers. If it was, then for that purpose and in that limited sense, as Mr. Justice Spelman put it, it is the agent or delegate of the charterers, and within the clause, but acts which are completely incidental or extraneous to that, as here, under different contracts, have got nothing to do with the charter party, have no bearing upon the status of the agent and have no bearing on the responsibility of the charterers under clause 49. And that, again, my Lord, is a very short point which really stems out of the correct interpretation of clause 8 and its application to the construction of clause 49, if the appellants are right on clause 49. My Lord, unless I can assist the court any further, those are my submissions on issue 2.
I looked over the adjournment at case we haven't been referred to, I think, number 2 in the bundle, the ANDRA, DTM Commodities Corporation. Is there anything you want to say on that? It may be that it isn't relevant, but...
My Lord, the ANDRA applied the test in the and the same approach in the Delta and what I've called for shorthand the Good Pal approach to identifying when the third party is performing an obligation on the behalf of the charterers, and in the ANDRA, Mr. Justice Popwell, applying that test to the facts, found that the particular acts of the receivers in that case were to be treated as acts of the charterers.
Yes, I mean, in that case, the receivers failed to discharge the cargo because they said that they wouldn't be prepared to continue discharging unless they were paid $2 million in respect of cargo, alleged damage to the cargo.
Yes, my Lord.
And that was held to be a failure to discharge.
Yes, my Lord, but your Lordship will have in mind, of course, that the obligations under that charter party were wholly different from those under the time charter party, in this case, because that was a voyage charter party case.
Yes.
And therefore the charterers would have an obligation to discharge the vessel.
Yes, so, I mean, you rely on paragraph 20 of the finding in the present case that Transclear wasn't, as this probably relates to Transclear's interference with discharge by issuing an arrest.
Yes, my Lord.
In respect to the ship as well as the cargo, but there was no evidence that that was in performance of cargo's obligation to discharge.
That's right, my Lord.
Slightly curious to find that as a finding of fact, isn't it? Isn't it a question of
well, my Lord, I think
law?
I think the difficulty was, my Lord, which is illustrated by my learned friend's dotted line in his diagrammatic representation, which seems to show a seamless chain.
We don't know.
We don't know. And therefore, that is why the charterers, the arbitrators correctly found that it is likely that they were some form of subcharterer, whether direct or indirect is not known. Now, my Lord, one just has to step back a little bit there, because that is important. Therefore, there was no evidence before the arbitrators as to the particular contract other than to which Transclear were party, other than the sale contract between Transclear and IBG.
Yes, I suppose you say Transclear may have been delegated with nothing relevant.
My Lord, just so. Take an example, which is not uncommon, where a trading company has a chartering arm and a trading arm. Yeah. The chartering arm may go out to book the tonnage. Yeah. There may be no back-to-back transaction between the trading arm and the chartering arm. And that might rise to some difficulties if ever they need to sue each other, which they don't usually. But the trading arm will be party only to the sale contract, and therefore the trading arm will undertake no obligation to discharge at all, because it is a CFO seller only. And so the finding of fact, as I read it, my lord, of no evidence was to reflect the very fact that there was a veil of obscurity over what the arrangements were between whoever it was, ... from Sigma, and Transclear. And the diagrammatic line is inaccurate in another respect because, of course, it seems to show that the sale contracts flow on as if in one seamless line from the subletting, which, of course, they don't, because the sale contracts stand outside the subletting line.
Right.
So, my lord, the ANDRA endorses the Adelpha, but applies the same test to the facts in a voyage charter party. And, of course, in a voyage charter party, the obligation of the charterer, which it may be being performed through the agency of the receiver, is entirely different from the obligation under a time charter party. And it's worth emphasising, my lord, that the only, if we are right on issue 1, the only obligation which is in play for issue 2 and was in play before the arbitrators is clause 8 of the charter party. So no exercise of a right on the behalf of the charterers was argued or contended for. The sole basis of the claim was placed on the basis that if we were right, then the charterers were the principals of the third party, because the third parties were the persons who were performing the clause 8 discharge obligation. So the focus in this case is entirely on what is comprised within the obligation in clause 8, and were Transclear and IBG performing that limited obligation, which is to execute the physical process of discharge.
Thank you.
My lord, those are my submissions.
Thank you very much. Mr. Boven-Siepen.
May it please your lordship.
Mr. Young.
I've taken on board your lordship's indication of a desire to finish within the day.
Yes.
I have taken the proverbial blue pencil to my submissions, and I hope I can do that. What I'm principally interested in doing is answering your lordship's questions, because most of what I was going to say is in one form or another already in writing. So if I can be understood as essentially responding to questions. But my lord, can I begin just by really pausing on a sentence which I think I heard my learned friend utter 5 times, which was that the charterers had, and I quote, nothing to do with Transclear and IBG. Now, if I may respectfully take issue with that,
yes.
and it picks up from the point that my learned friend has just been making, because it is, I'm afraid, analytically incorrect. And if I can do it in this way, that like any time charter on the New York produce or similar form of charter, Cargill could delegate the performance of charter party functions, rights and obligations, but I'll call them functions, to others, and thereby create an agency as is commonly understood in the chartering market, and importantly, commonly understood in the cases. It is a process of delegation which is familiar, and it is characterized and called agency, even though it is not a contract of agency as dealt with by Bousted.
Is it even necessarily a process of delegation? I mean, vicarious performance may involve delegation, but not necessarily.
Absolutely not necessarily, my lord. It is, if I could call it, a process of subcontracting by one means or another.
It's the vicarious performance of obligations and the vicarious enjoyment of rights.
Correct. But by one means or another, and it's the point that my Lord Sumption made earlier, that one can delegate the performance but not the responsibility, and I'm taking the word delegate there, of the functions. Now, consistently with that ability, and consistently, of course, with the Nanfree, famously, there was no compulsion on Cargill to subcontract the performance of charter functions in any particular way or in any particular form of subcontract. The choice of subcontracting terms and the circumstances of those subcontracting terms was a matter entirely for Cargill and those to whom Cargill gave the right to make subcontracts down the line. It was Cargill had control over the form of subcontract which it was prepared to authorise and permit. It could do so by saying you may only subcontract on such and such terms. If it chose not to do that, but gave a broad authority, then it gave that broad authority to those down the chain to make such contracts to perform particular functions as they saw fit, and whatever terms they could succeed in agreeing. There was absolutely no requirement that subcontracts be on terms identical to the identical to the charter party, and likewise no obligation to create a contract of agency properly so called. The form of subcontracting was entirely in the hands of Cargill as to what they did and did not authorise. Here, the exercise of Cargill's right of subletting and subcontracting was what turned out to be a sequence of changing types of subcontract, but authorised nonetheless. It's the point that my learned friend raised about my diagram. We do not know what the relationship, if there was any relationship.
This is the bottom of page 84, is it?
That's exactly right, yes.
Yep.
We do not know, because there are no findings, and Cargill adduced no evidence, and there was no evidence. We do not know. What we know is that it was a time charter trip to Cargill to perform a contract, a voyage charter contract, which they had with Sigma, who were a Swedish cement exporting company. We do not know how Sigma dealt with it thereafter. What we can say is that there would have been lay-time and demurrage clauses in the contract that Cargill made with Sigma because it was a voyage charter. Sigma may have done what my learned friend said, which is have an in-house arrangement, we do not know, with the sellers of cement. They may have sold directly to Transclear. But by one means or another, Transclear acquired an involvement in the charter or subcontracting chain. Now, pause there. If they had done nothing with the goods, they hadn't sold it on, they dealt with it themselves, they would have taken it to Port Harcourt and they would have discharged it, probably by employing stevedores for that function. They could have discharged the cargo. They decided not to do that themselves, but they performed their role of discharge of the cargo by making a contract with IBG, whereby IBG undertook that function. So Transclear had the obligation to discharge, but they passed it on seamlessly to IBG. Each of them had an obligation to discharge the cargo. Now, they may have had an obligation to discharge the cargo within a particular time. Probably, given that Sigma were voyage charterers, there would have been some form of lay-time and demurrage provision thereafter, because only an idiot would voyage charter without passing on lay-time and demurrage in some form or another. So the chain of subcontracts, which was generated by Cargill's free delegation, free authorization of subcontracts, was, among other things, to create a contract for discharge which included lay-time and demurrage provisions. And if the discharge was not performed quickly enough, by reference to the terms of that contract, then demurrage would accrue, as indeed it did here. The vessel tendered notice of readiness at Port Harcourt, but because the tribunal said there was congestion contributed to by the fact that IBG's loader was not working, when they should have been discharging, they weren't. The vessel was actually just sitting out at the anchor. That is the point upon which my learned friend latches his argument and says, because the vessel was sitting out at the anchorage, even though lay time for demurrage, for discharge was running, IBG were not actually in the course of cargo handling. They weren't humping and pumping the cargo out. They were sitting waiting with an obligation, which was configured as ultimately as demurrage. Now, it is by that process of subcontracting of the obligation to discharge with the authority to create lay time and demurrage provisions that what we have had in this case...
Do we know when the notice of readiness was given?
Yes, it was the 18th of October, I think, my lord. I say that. The notice in the... The answer is yes, I do. It's the 15th of October. It's paragraph 9 of the award, page 141 of the MS bundling.
Thank you.
And she then waited for 2 months and then went into berth on the 18th, where she was met with the arrest of both cargo and vessel, mistakenly the vessel, so that the vessel was then pushed off again, because Transclear had actually prevented discharge from taking place. So the very people who had acquired the obligation to discharge and passed it on to IBG then obstructed it. They positively performed their obligation of discharge by obstructing it. Now, with the greatest of respect, my lord, unless one can say that it is not a breach of an obligation by a subcontractor to obstruct the performing of the very function which has been delegated to it, in my respectful submission, it is very difficult to see how that cannot adequately be within the terms of this clause 49.
You talked a moment ago about authority to create marriage provisions. You just talked about Transclear in breach of their obligations to discharge, but there was no authority in the main charter, the time charter, to create demurrage provisions.
No.
The time charter is simply silent on the subject, and that any demurrage, any lay time and demurrage provisions in a contract of sale are no interest whatever to the owners.
It's just a license to...
It's a license. My lord...
They can use the ship, but you can make any sort of contract you like in relation to the ship, as long as it's consistent with the head charter.
Well...
Or authorised, it's just got to be consistent.
Yes, and to do so with lay time and demurrage terms is not inconsistent.
Yes, but okay. You then spoke of Transclear having obligations, but they haven't got any relevant obligations as regards discharging to your clients.
Well, they do, actually, my lord, if I may respectfully say so, because we have the findings of the tribunal was that it is likely that Transclear were voyage charterers by one means or another. That's paragraph 40, my lord, MS 151.
Thank you. Yes.
The precise role of Transclear wasn't entirely clear on the evidence. Transclear was plainly the seller of the cargo. Since the price of the cargo was CNF free out Port Harcourt, it seems likely that Transclear was also the sub-charterer.
Yes, but I said they have got obligations to your client. They may have obligations to Sigma, possibly, we don't know, but that's irrelevant.
My lord, when you say they have no obligations to my client, they had an obligation to discharge the cargo. That was their obligation.
I'm not sure about that.
Sorry.
No. Well, they weren't. I mean, this may sound naive. They weren't obliged to carry any cargo at all.
Hang on, who are you, if I may respectfully say so, who are you talking about?
We're talking about cargo.
Cargill, I quite agree.
But all they undertake is that if they give instructions to the captain to carry cargo, which they're obviously going to do, they are responsible for the expenses associated with it.
Correct.
It's a bit of a step from that to say that they owed some positive duty which through Transclear was breached, isn't it?
No, if I may respectfully say so, my lord, your lordship said it seems naive. If you'll forgive me, exactly. What has happened is under the, and I'm sure your lordship's brethren will agree this, that clause 8 of the New York Produce imposes such obligation of cargo handling as the charterers wish to perform onto the charterers, so that they are themselves vicariously liable for cargo damage done. But it is perfectly true that Transclear had no direct contract with Cargill. That's absolutely right. But they were nonetheless performing the process of that discharge which Cargill had, by exercising its right to load cargo, wished to be performed at Port Harcourt.
The point that you've got to make good is that we aren't concerned with obligations here at all. We are concerned with the vicarious enjoyment of rights.
Correct.
And you've then got to make good the point that that is sufficient to constitute somebody as an agent for the purpose of Clause 49.
Yes. Cargill, as my Lord Toulson said, Cargill did not have to load any cargo at all.
No.
But if they did load cargo and they did cause or authorise bills of lading, which they clearly did, and I'll show your lordships the passages in the Charter Party which deal with that, then among other things, they have necessarily undertaken the obligation of securing discharge of that cargo.
The rights come with the taxed obligations.
Yeah, yes. Cargill could have sat with the vessel doing nothing as long as they paid hire. They had the right.
Delivered at the end of the time-chartered voyage with cargo on board. That's the point.
Yes, indeed. So it is, if I may respectfully say so, my lord, it is a right which Cargill had, which Cargill chose to avail themselves of by causing cargo to be loaded and causing bills of lading to be issued, which, among other things, required discharge at Port Harcourt. Having done that, they then undertook the obligation, not necessarily one limited by time, but they took the obligation to take cargo out of the vessel.
But your qualification about time is important, isn't it?
It is an important one, that's why I made it.
They had an obligation before redelivery to take the cargo out.
Yes.
They didn't have an obligation to do it at any particular moment before then.
Your lordship is
either marriage liability.
Your lordship is absolutely right about that, but the contract which was put in place, whereby they actually secured the discharge of the cargo at Port Harcourt, which was an authorised one, did incorporate the terms of lay time and demurrage. So while Cargill may not have had any contractual obligation vis-à-vis NYK to discharge within any particular period of time, the subcontracts which they put in place to achieve that discharge did generate that a time-related obligation. But your lordship is right.
As between two other people who have nothing to do with this owner and this charter.
You're quite wrong, if I may respectfully say so, my lord, to say they were nothing to do with. They were the very people who were, by a string of subcontracts, engaged.
I appreciate that the sale contract wouldn't exist, or well, probably it would exist, actually. It wouldn't relate to this vessel. But nonetheless, in terms of the time charter we're concerned with, as my lord says, all that matters is that the cargo gets off by redelivery.
Yes. But unless, of course, the charterers secure the issue of bill of lading, which says that it should be taken off at Port Harcourt, which they did.
That would be a direct obligation of the disponent owners if the bill of lading was issued.
Indeed.
Assuming it was an owner's bill.
Yes.
But, I mean, what this discussion illustrates, surely, is that while there were obligations, your case has to turn on the proposition that the vicarious enjoyment of rights is a sufficient basis for agency under Clause 49. The obligations won't help you to get there. that the timing is completely different.
The obligation
timing
to
is
explain.
crucial to the problem that we're concerned with quite often.
If I may respectfully say so, my lord, had it not been that the contracts by which the discharge was arranged not themselves introduced time-related obligations, I would agree with your lordship. But if Cargill so delegate the performance of the obligation function, if I can call it a function, by terms which incorporate lay time and demurrage terms, which clearly, having voyage chartered on to Sigma, they were contemplating. I see my Lord Mant shaking
That's
his
where I have a
head.
difficulty in speaking of delegation of something which doesn't actually exist under the time charter.
It's delegation of a function, my lord. It's the function of
Simply
discharge.
Then the only function that exists under the time charter is discharging before redelivery.
No, my lord, it's to discharge in accordance with the terms of a bill of lading as issued and imposed upon the owners.
Where do you find that?
Well, it's
Is that a time charter obligation?
That's a time charter. It's a time charter obligation because the time charterers are entitled to require the owners to issue bills of lading as presented.
But does that, yes, if they do that, then I suppose under the employment and agency clause, they have an obligation to procure. Well, no, they don't. There's simply a relationship between Cargill and bill of lading holder directly. As far as Cargill is concerned.
No, not directly. It'll be because the owners will be, if it's an owner's bill, Cargill are only.
Sorry, yeah, yes.
I'm sorry, my lord. Forgive me.
I misspoke. There'd be an obligation between the disponent owners and the bill of lading holders directly.
Well, I would say head owners rather than disponent owners, my lord.
Right.
Because it's. I'm sorry. I'm being.
I
pedantic.
don't think that affects the point that I'm making.
Yes.
If
I
one
agree.
looks at what the status of Cargill is, they did not have obligations. They had rights.
Yes.
And those rights are the only peg on which you can hang your agency.
Were it not for the fact that having exercised those rights to load cargo and to cause bills of lading to be issued, which impose upon the owners the obligation of discharging,
Yes.
Of carrying to the port of discharge, and then having that cargo discharged.
But now, is it your submission that if you procure a bill of lading, an owner's bill of lading to be issued, you, as the time charterer, have an obligation owed to the head owner to procure the discharge,
Yes.
as opposed to there simply being an owner's obligation through his crew
Well, the owner's
to
obligation.
operate in the discharge owed directly to the bill of lading.
The owner's
No one else
obligation.
engaged.
The owner's obligation is not to discharge
Well,
under the bill of lading.
yes, he has to.
It's to permit delivery.
He has to permit it, and that may
Yes.
involve certain operations
I
on
quite
the
agree.
side of the rail.
I quite agree.
But the discharge is contractually surely solely a matter between NYK and the bill of lading holder. Cargill may have procured it, but they don't have any obligations arising.
Well, I'm sorry to be difficult about this. They secured that a bill of lading was issued requiring the vessel to go to Port Harcourt and there make itself available to give discharge of the cargo. Having done that, they having undertaken the obligation under Clause 8 to do the cargo handling, they did have that obligation. They crystallised that obligation by authorising and as presented the bill of lading.
This is becoming a bit mysterious to me.
Well, let me try and clarify.
I haven't noticed any references to the bills of lading in the cases, and it may be an interesting and important area, but correct me if I'm wrong on that. There is a clause, Clause 8, which deals at the end with the consequences of issuing bills of lading, which are reasonably familiar.
Yes.
And on the face of it, the bills of lading give rise to separate obligations between the owners and the bill of lading holders. The charterers may have to answer for discrepancies as a matter of law between the charter and the bills of lading if they expose the owners to larger liabilities. But at the moment, I don't see that that's ever whether that has any relevance in this case.
I'm obviously not making my point clear, my lord. If I may try again. The obligation of the charterers, the charterers, this is lines 145 and 146, right. The charterers are to perform all cargo handling at their expense under the supervision. Now, if they require the vessel to go to Port Harcourt and deliver cargo under a bill of lading which they have required to be issued, then when cargo comes to be discharged at Port Harcourt, it is they, the charterers, Cargill, who must perform all cargo handling.
Yes.
They have generated an obligation out of the exercise of their right.
Yes. What's that got to do with the bills of lading? There may be separate rights or duties under the bills of lading.
Yes, but
they may be the same or they may be different.
They may be the same or they may be different, and that generates rights of indemnity potentially. Yeah. But the point is, my lord, that Cargill, by their orders, load cargo of cement, go to Port Harcourt, deliver cargo of cement. They have undertaken the obligation of performing the cargo removal, the cargo handling at Port Harcourt
so
when it comes to be done.
On lines 145 and 147
Correct.
Would be exactly the same, even if no bill of lading had been issued.
As long as there is an order,
or a charterer's bill had been issued.
Yes, as long as there is an order. You're absolutely right, my lord.
So that's why I asked what the bills of lading got to do with it.
Well, it's only because they themselves then create a direct obligation between the cargo receivers.
But that's not the matter that you have to rely on.
You're absolutely right, my lord. No. But it's clause 8 which, in the circumstances, generates the obligation to discharge to cargo handle.
Well, that generates an obligation to perform all cargo handling at their expense. Yeah. In other words, as and when they get round to it, and they aren't, since it's a time charter, there's no particular compulsion to do it at any time or with any speed. If they choose to normally delay, that's up to them.
Yes, but if they put in place a series of subcontracts, directly or indirectly, under which then, and what exactly has happened in this case, there was then a dispute as to the performance of the contract of the subcontract for the discharge of the cargo.
Your sentence starts off, if they put in place a series of subcontracts, then how does the sentence continue?
If they put in place a series of subcontracts for the discharge of the cargo, with the object of securing the discharge of the cargo, and those subcontracts include obligations of lay time and demurrage, which themselves then generate the dispute between the parties to that chain, which cause the arrest of the vessel, then that is entirely the consequence of the subcontracts of which they have authorised the conclusion.
Suppose that there were no subcontracts. How would lines 145 to 147 operate? I mean,
if there were no subcontracts, just Cargill.
Yeah, as I understand it, your submission is that although the lines 145 and 147 are not time related, the fact that this is a charterer's function at some stage is enough to make them an agent.
Yes.
And therefore, if they hang around for a long time, for whatever reason, they can't claim that they're going to hang around for a long time at the owner's expense. They've got to pay higher.
That's right. And what's happened here is that because of the subcontracts of which they have authorised, there has been a dispute which has caused the vessel to be arrested by one subcontractor against another subcontractor.
Well, I mean, I understand this argument, but what I totally fail to understand is how the existence of subcontracts helps that. Because if there weren't any, I think you're suggesting your argument based on those three lines would be the same.
Exactly.
So why are we worrying about subcontracts, bills of lading and all
the only reason subcontracts come into it is because there was a dispute between one subcontractor and another within that chain. arising out of the terms and the performance of the discharge obligations, which were...
So that's part of the factual
Part of the
historical
factual matrix.
explanation,
Yes.
but has no legal
It
significance.
has no legal significance, but that's how that's the factual circumstance that is the foundation of this case.
Right.
If there was no bill of lading and it was simply Cargill discharging its own cargo, there would be no occasion for an arrest, because Cargill would have no complaint against Cargill about how the discharge was undertaken. The cause of the arrest is solely and distinctly because of the terms by which Cargill subcontracted the discharge.
Right.
So that's where the subcontract comes into it.
Yeah.
And it is solely because of the subcontract terms that the dispute which generated the arrest comes into being at all. So, if I may say, my Lord Sumption is entirely right in terms of the identification of the obligation in Clause 147 of the Charter Party, but the circumstances of this particular case which generated the arrest were a dispute between subcontractors about the terms and performance of the subcontract for the discharge. So when my learned friend says Cargill had nothing to do with that dispute, they had everything to do with it in the sense that they had generated the subcontracts, and one can put it the other way, the owners, NYK, had correspondingly less to do with it. Mr. Rainey says they had no control over it. They could have had control over it by saying you cannot subcontract in terms which permit arrest or which generate obligations of demurrage which will be used to secure an arrest. But they didn't do that. They have put in place these subcontractors. So to say they have had no control or nothing to do with is, if I may respectfully say so, quite mistaken.
A bit difficult to suppose that anyone in their right minds would think of putting in a clause which said, you shan't arrest the ship for a claim for demurrage or which you have against a seller. As you point out in your case, it's the wrong way round.
It is entirely the wrong way round.
I mean, this is the most bizarre factual background to decide important points of law.
Your lordship is absolutely. I'm at one with your lordship on that. It is completely the wrong way round.
Yes. But you were suggesting it could all be catered for by express instructions, but no one would ever give instructions against the sort of error that occurred here for unexplained reasons.
My lord, nobody would think of it because it's so bizarre. But to say it's out with their control is another matter altogether. They could say, you can subcontract on terms that you do not arrest the vessel.
Well, that would be, I rather suspect that that would be completely unforeseeable for different reasons, that for cargo interests not to be able to arrest a vessel when the goods are turned out damaged.
I'm going to come to the particular point that was worrying your lordship at the very outset this morning. But what I'm anxious to do is to ensure that my learned friend's suggestion that they had no control and it had nothing to do with them, what their subcontractors did as between themselves when they had a dispute about how the cargo was to be discharged, is completely false.
I have a difficulty with your proposition. As I understand the argument, it runs as follows. Cargill has created or permitted the creation of obligations to itself or to its subcontractors involving payment of demurrage.
Correct.
Ergo, default in performance of those obligations to Cargill or its subcontractors constitutes a default by Cargill within the meaning of clause 49.
No, only if Cargill arrested the vessel. Clause 49 has got nothing to do with vicarious liability.
So you're not relying on OBG's default in payment of demurrage?
I'm saying that OBG's default in payment of demurrage was an act or an omission in the performance of the function which they had undertaken.
So you are.
I am,
yes. So, well, then the proposition I was putting to you represents at least part of your argument, because you're saying...
Yes, but...
Yeah.
But
okay.
my
well,
Lord...
then that seems to me to be translating a breach of an obligation to Cargill under a string of subcontractors to a breach of an obligation by Cargill within the meaning of a charter party.
No, my Lord, no. It's because clause 49 is in the context of an arrest in support of such a claim. Mm-hmm. If Cargill had arrested the vessel in support of such a claim, then it would not be an arrest. It would be an arrest within the proviso of clause 49.
All right, so you're not... Because we've got to... we're in danger of losing sight of the different acts which you rely on as an act or default. You don't rely on the act of... or default of OBG per se. You are relying on the conduct of Transclear as giving rise to the...
I do both, my Lord.
Right, well, okay. Well, you are...
Can I explain why?
Well, you can remember, but when you... In the course of doing so, I'd be grateful at some stage for an explanation, insofar as you're saying that the default of OBG is a relevant default, then it seems to me that it's a default of OBG to Cargill or its, in inverted commas, agent.
Correct.
Which you are then translating into a default by Cargill. And
no.
Well, anyway, that moment seems to me to be a difficulty in relation to your argument based on the default by OBG. I do appreciate that you also say, well, hang on, there's acts by Transclear which quite separately amount not to a default, but an act triggering 49.
Can I, my Lord, it sounds silly, but may I just take you back to clause 49, which is page 174 of the bundle?
Yes.
Because I've clearly not made the point that I wish to make adequately. This is about arrest. It's not about performance of obligations, it's about arrest. And unless, it's really just the proviso, unless such capture or seizure or detention or arrest is occasioned by any personal act or omission or default of the charterers or their agents. Now, what I'm saying is that if the arrest by whomsoever it is who is arresting is occasioned by the act, omission, or default of those people, whoever they may be, charterers or their agents, then that arrest falls within the proviso and therefore the vessel is not off hire. It's all about arrest. It's not about whether obligations are owed either to or by Cargill. It's whether there is a relevant act, omission, or default.
In other words, it doesn't have to be a breach of some other obligation to arrest the ship. All that you have to establish is that whether a breach or not, it arises from something that Cargill or someone performing a relevant function on behalf of Cargill has
exactly
done.
I mean, if I may, my Lord...
you say it's occasioned by Cargill because they set this arrangement in motion.
No, I don't say that, my Lord.
So how is it occasioned by?
It's occasioned by the act or omission or default by the agents who are, for these purposes, Transclear and IBG. And I understand I've got to make that good.
How can you put the two together? I mean, there's no contractual relationship, so you can't pin any responsibility on Transclear. And Transclear don't arrest.
Hang on, if you'll forgive me, my lord.
Well, there's a chain.
That sentence, if you'll forgive me, conceals, and I don't mean
I'm
that
sure
really.
it conceals a fallacy.
It conceals a fallacy, or at least a number of
Conceals
unstated
an
premises.
assumption. Conceals an assumption.
It conceals an assumption. Do forgive me. What there is an arrest by somebody, usually a third party, actually, not necessarily to somebody to the party to the. Ask yourself, what is the cause of that arrest? Is it an allegation of, and I'd say an allegation of, an act, an omission, or a default? The default, if you had to have a breach, the words act or omission are irrelevant. So it's something that is done or not done, which may or may not be a breach of an obligation. And it may or may not be an obligation under this charter party.
Yes,
You simply ask yourself, what is the cause of that arrest? Here, it's much clearer because it is actually specifically to do with the performance of this charter party.
If Transclear had nothing to do, let's suppose there was some arrangement down the line between IBG and some sub-buyer, that IBG would pay the sub-buyer demurrage if IBD didn't deliver this vitally required consignment of cement by a certain date, and that didn't happen. And the sub-buyer began proceedings against IBG and claimed to arrest not only the cargo, but also the ship. Now, you couldn't possibly argue that the sub-buyer then was an agent.
No, but
why does it make all the difference that Transclear, who has no contractual relations with your clients, no actual responsibility for discharge, happens, pursuant to a demurrage claim which it has under a sale contract, to issue a misguided arrest against the ship?
Well, you say, my lord, it has no actual contractual relations with
your client.
With my client. What my client has done is chartered to Cargill. Cargill have chartered to Sigma. Sigma have, by one means or another, contracted with Transclear.
Well, we don't actually know that, but we assume.
We don't know that, but whether there was a gap between Sigma and Transclear, we don't know. But there is a directly traceable...
So that makes all the difference, does it?
Yes, it does.
I don't understand the logic of that. I mean, it seemed to me that it's the example I gave is an illustration of why you might want to tie the concept of agents into something which is actually being done, which is directly
well, that I do. That I do in relation...
Charter, directly related to a head charter, either obligation or performance of a right.
That I do, my lord, in relation to the facts of this case, and essentially issue 2, that what happened here was that IBG and Transclear separately undertook to discharge the vessel, and it was in performance of that discharge operation, that discharge function, that the vessel was delayed and the demurrage claim resulted. I say our case is unusual because of the facts, which actually make it, I would respectfully submit, an a fortiori position. But what this clause is principally aimed at, I would respectfully suggest, is a third-party arrest. If I can just take the example of a claim against Cargill, leave aside altogether the notion of agents. Let us suppose that a bunker supplier to another of Cargill's ships has arrested the vessel. And let's face it, that is a perfectly common event. One would say that if the bunker supplier has not been paid for the bunkers by Cargill, then Cargill's act, omission, or default, and it's probably all of those, has occasioned the arrest. It doesn't have to be in relation to this charter party at all.
Would your submission, does it make any difference to the way that this works, according to your submission, whether the arrest is justified or not.
No, it
we
doesn't.
know that in this case it seems to have been an idiotic mistake. But your submission would be exactly the same.
Exactly the same.
If there was a perfectly sound cause of action against the ship and a perfectly justified arrest.
A perfectly sound cause of action against the ship.
Yes.
I'm just trying to think. Your Lordship would have in mind
Cargo damage, for instance.
cargo damage. Well, that would plainly fall. I would respectfully submit plainly fall within the main body of Clause 49.
When you say so,
Why?
why is that?
Because it doesn't fall within the proviso.
Why not? It's an arrest by cargo who, let us suppose they are, as in this case, responsible for discharge.
I've been dealing with the question that was put, which is a cargo claimant against the ship arrests the ship. I haven't been dealing with the particular, this particular cargo owner. I can deal with that.
Let's take this particular case. I think your submission is that the obligation under free-out terms to procure discharge owed by IBG was the manner in which Cargill's obligation under Clause 8 was performed.
Correct.
Albeit that there was no direct contractual nexus.
Correct.
Your submission, I think, would be exactly the same, even if the cargo had turned out damaged and IBG had arrested the ship in the course of discharge
But
with every right to do so.
2 points, my lord. During the course of discharge,
Well, it'd have to be during the course of
yes.
discharge in order to give rise to this particular problem.
I quite agree. But if it was the result of a breach of contract by the owners, then that would trump the off-hire proviso, because that it would have been brought about by my breach.
Well, let's vary the facts and suppose that it's actually yes.
Can I?
I think it's a bad claim. I mean, you never know with a cargo.
No.
One of the cases we were looking at was a bad claim. That you say then that the vessel would remain on hire simply because the receivers chose to make a bad claim.
This goes back to the point that my Lord Mance asked my learned friend about at the beginning. Can I give my answers to that problem? Because his question was, it's unusual, isn't it, that there is no authority on this sort of clause where there has been a perfectly normal arrest by cargo receivers of the vessel. Now, within that question, there are, I would submit, two questions. One is, why is there nothing in the authorities? And two, how does this deal with the question of the lawful arrest by cargo receivers under this string of contracts? As to the former question, why is there no authority? First of all, arrest is not by any means often an off-hire event. Secondly, as in this case, it is very common, I mean, it was in this charter, there was at clause 41, which is at page 173 of the bundle, there was an express incorporation of the New York Produce Interclub Agreement,
Yes.
whereby both owners and charterers have club entries. I think it was my Lord Mance who said it's unusual for charterers to have
I
P&I.
said they might not have a.
They might not, but
P&I.
here it's very common, and there is the Charterers Club, and Charterers P&I cover is very common, and they supply a lot of security for arrest. But if I can just show your Lordship, I've handed it up, the Interclub Agreement, which actually deals with it and explains why the problem doesn't
Yes.
arise. I've handed it up. I'm afraid it hasn't got a super supplementary authorities provision, that if you go to page 8, this is from Wilford on time charters, page 887, clause 9 of the interclub agreement. And this, I think, will explain to my lord the nature of the point. If a party to the charter party provides security to a person making a cargo claim, that party shall be entitled upon demand to acceptable security for an equivalent amount in respect of that cargo claim from the other party to the charter party, regardless of whether a right to apportionment between the parties to the charter party has arisen under this agreement, provided that written notice is given and there's a reciprocal arrangement. So the reason it doesn't arise in practice is that because you've got both owners and charterers who both have club entry and they have cargo claims being divided up by in accordance with the New York Produce Interclub Agreement, whether it's expressly incorporated or merely operates as it does between clubs, there is, in a sense, a mutual security for arrest obligation. That's why it doesn't arise in practice. Because it doesn't matter who puts up the security, because each of them has got to secure it. But the point is, my lord, that if there is an arrest by a receiver, he is doing so qua receiver as a party to a contract under a bill of lading directly with the carriers. He's doing so not as a subcontractor, but as a direct contractor with the head owners, which is entirely different. The character of his involvement is not as a subcontractor, but as direct contracting party under a completely different contract.
I'm not sure how that fits with your argument that the bill of lading is just a method by which the charter may arrange to perform his obligations.
No, that's not my argument.
I mean, well, supposing that the receiver under the bill of lading is the person who, under the sale contract, has ultimately become responsible for discharging, isn't the receiver then somebody who, in your terms, is performing cargo handling for the charterers?
He's not. That's why I characterize him differently. It may be that he's wearing two hats, but I would respectfully submit where he is claiming as a direct party to the bill of lading contract, and for these purposes, Cargill fall out of it, because it is a direct contract between head owners and receivers, consignees, receivers. They sue the ship as parties to that contract. It's got absolutely nothing to do with their involvement in the discharge of the cargo. But also, one other reason why it doesn't happen very often, is that normally discharge will be complete before the arrest is effected, in which case the agency to perform discharge has actually been exhausted. But if there is an arrest while discharge is taking place and it prevents discharge, the other reason why it doesn't happen very often is that most off-hire clauses of this sort will be net loss of time, and there will be no net loss of time when one is actually discharging the cargo. So that's why it doesn't happen very often. But the direct right of a receiver under a bill of lading is quite distinct from this contract, not to arrest in clause 49. And added to which, if there is a breach by the ship It doesn't matter for the purposes of the allocation under the New York Produce Exchange Interclub Agreement, of course, but if there's a breach by the ship which has generated the arrest, then that, as I say, trumps their claim for hire. Because it is common ground that if an arrest is due to a breach, then it is covered by damages. And that's why, my Lord, Lord Mance's questions, how they are dealt with under this particular charter and in my particular argument. It is, I do not say that somebody who has at one time undertaken an obligation of discharge, who in an entirely different character effects an arrest, is necessarily within the proviso, particularly when that arrest results from a breach of contract by the ship owners. That isn't our case here, though. Our case here is that the party who is performing the act of discharge as required by or asked for by Cargill does so in terms which expose him to a liability which causes the vessel then to be arrested. And absolutely nothing to do with the ship. My Lord, I think, raised the question of the ANDRA. My Lord Mance mentioned the ANDRA. A number of cases that my learned friend referred to without actually taking you to. That was, I think, going to be one of them. It's in tab 2 of the authorities bundle. This was the case, I think, that your lordship had in mind, as it were, the bad arrest with the what I can only describe as blackmailing security claim. There was there was some undoubted unseaworthiness on the vessel which caused damage, but there was a claim for security which was in April, wasn't ultimately satisfied until October, during which the discharge had not taken place. And what Mr. Justice Popplewell held, I think it appears in the head note, is under clause 5 of the this is halfway down the holding, I suppose the whole holding. Although the award wasn't couched in language of fault or self-induced frustration, the tribunal found that the event which was relied upon as the frustrating event, namely the continued existence of the April order of the veterinary service, was itself caused by the conduct of the receivers in failing to discharge the cargo for so long as they were maintaining an unjustified attempt to be paid $2 million. The tribunal expressly found that it was not some outside event which precluded the unloading of the cargo, but the receiver's choice to interrupt discharge. Under clause 5 of the charterers were under a non-delegable duty to discharge the cargo, even if, as between the charterers and receivers, it was the receiver's obligation to discharge the cargo. The position under the charter party remained that for the purpose of performing the charterer's obligation to discharge the cargo, the receivers were agents or delegates of the charterers, and the charterers remained responsible. So one can see that where the receivers were obliged to discharge the cargo, the operation of the veterinary order, which ultimately was relied upon as a frustrating event, was held not to frustrate because that veterinary order applied because of the failure of the receivers to discharge. Now, my learned friend says, well, that was a voyage charter. But so far as relevant discharge, cargo handling obligations are concerned, there is absolutely no distinction between a voyage charter and a time charter. So what this case does, the ANDRA does, and I think this is what my Lord Mance identified and asked Mr. Rainey about, was exactly how the malperformance of a discharge function, obligation, caused the detention and caused what would otherwise have been a frustration. So this case actually shows precisely how there is an interaction between the discharge process and the claim for security.
So how does that work on the facts of this case? We have the arrest is by Transclear.
Arrested by Transclear.
And
Because-
is that said to have been a time when it ought to have been discharging Cargill's obligations to discharge under the contract?
Yes, Transclear was going to discharge the cargo, but it chose to do so by selling the cargo on free-out terms. So what it did was it had the obligation to discharge, but it performed or sought to perform that obligation by subcontracting it to IBG. But it couldn't get rid of the obligation, but it could get the obligation performed by IBG.
Is it not said on the other side that the arrest, if you like, took place before the agency came into existence?
Well, that's what my learned friend does say. He says,
What's wrong with that?
He says, what's wrong with it is this, that first of all, it is premised upon his very confined prepositional phrase, in the course of discharging. That anything which happens during the period of time when the discharge function has been undertaken, that's from the moment of
And on the facts, a proposed discharge had been suspended, had it? Or have I got that right?
Yes. It was came into birth on the 18th of December, ready to discharge, and it was met with the arrest order which prevented the discharge of the cargo and erroneously caused the arrest of the vessel. And had it not erroneously caused the arrest of the vessel, there would have been absolutely no problem. But it was entirely erroneous. But it was the prevention of the discharge of the cargo which was the effective exercise that was undertaken.
But there was that, and the point against you is that there was absolutely no obligation to discharge the cargo at any particular time. All that Clause 8 involves is that when there is cargo handling, then charterers must pay for it.
That's absolutely right. But it's a function, which is the point made by my Lord Sumption, that it's the exercise of a right by Cargill to load cargo and then to ask for it to be discharged pursuant to a bill of lading, which generates a sufficient act, omission or default, which causes the demurrage obligation to accrue and thus the arrest of the vessel.
Isn't there a distinction from the ANDRA due to the fact that the ANDRA is a voyage charter case where the charterers were under a specific obligation to discharge with dispatch or whatever the laytime provisions required? And that means that anyone who's doing the discharging was actually affecting charterers' performance of a voyage charter obligation.
But likewise, the time charter obligation to discharge. When the vessel came in, the function to be performed was discharge, and that was to be performed under Clause 8 of the time charter by Cargill or whoever, the agents.
Well, in theory, the charterers could have said, we don't want to discharge, we'd like to wait 2 months.
Well, strangely...
We're very happy to pay the time charter hire.
As long as they pay the time charter hire, no problem.
Yes, but in theory that's right, isn't it?
In theory, that's absolutely right. The question here is, and in a sense, of course, if I may put it at its bluntest, they having voyage chartered to Sigma, let us suppose which they had done, that's plain, that voyage charter would have given rise to potentially a liability to pay demurrage for the use of the vessel, for which Cargill would not be paying because of the arrest. So they'd be claiming demurrage for the use of a vessel which they didn't have to pay for by way of
Do we actually know this?
We don't know it, my lord.
This is... I notice you put it in the case, and it's an interesting speculation, but it is an odd situation.
Well, it's an odd situation, but it's one which one would expect to encounter with a time charterer who voyage charters the vessel on, that there will be laytime and demurrage provisions.
If for some reason, perhaps this ground's been gone over, but looking at Clause 8 of the original Charter Party on page 166, if for some reason there'd been a decision, to put it neutrally, not to offload any of the cargo at Port Harcourt, and the ship and vessel had simply left, would the charterers have been in breach of Clause 8?
If the vessel had simply left, then she wouldn't be under arrest.
Well, quite. But I mean, the point I think it's being put to you, and I'm putting to you again, really, is how does Clause 8 help you, therefore?
I do not need to say there was a breach of an obligation to discharge.
Well, I understand that.
All I need to say is that there was an arrest which was occasioned by an act, omission, or default by somebody who was employed by, directly or indirectly, Cargill, to effect the discharge.
I understand that, but I will repeat my question. Why does Clause 8 help you, then? What relevance has it got to your case?
So far as it imposes an obligation, it helps me, but it's not essential to.
But it's not an obligation which is relevant to what happened.
No, exactly.
Therefore, I'm sorry, I don't understand why.
No, well, I'm.
Your case that it's simply relevant to the status of the person doing the discharge.
Correct.
As an agent or not an agent.
Yes.
It's not relevant to the breach.
No.
But it is relevant solely for the purpose of identifying the agent,
Yes.
somebody performing the Clause 8 obligation vicariously.
Yes, exactly.
You mean because they agree
my Lord
to...
Lord Sumption has got it.
You mean what they do is they agree to perform all cargo handling at their expense, is that right?
That's correct.
So because they agree to do it at their expense, that's the obligation you alight on. Is that right?
Well, it's to perform all cargo handling, so that when whoever it is who in the chain of subcontracts is to perform the cargo handling, they do so as agents of Cargill.
I see.
It's an identification of agent, not necessarily the expense, although that.
So if we look at page 31 of the, unfortunately I'm operating off for the old-fashioned numbering, but in the award, paragraphs 9 onwards, we have an account of the facts. These are the relevant findings of fact. The vessel arrives at Port Harcourt on the 15th. On the 18th, she goes to berth. For the
18th of December.
18th of December, sorry, yes. Sorry, that was the 15th of October.
15th of October and 18th of December.
On the 18th of December, she proceeds to berth with a view to discharging.
Yes.
And moreover, to be discharged by Cargill.
By Cargill.
Or pursuant to Cargill's obligations, see paragraph 13.
Exactly.
Then she's arrested, paragraph 11. And then we say on the same day, Cargill gave orders to the master in the following terms and so on. Namely, please do not discharge.
Please don't discharge it.
But on the basis that until then they had instructed or implicitly instructed the vessel to discharge, to be discharged by Cargill or their subcontractor, if you like, who was either Transclear, or indeed IBG.
And it was a matter of complete indifference to Cargill, which it was, of course.
And you say that's all you need. You don't really need the
exactly
Clause 8 at all, except as a...
well, Clause 8 identifies the function which is being performed. I don't, and I'm very glad that this error of my exposition has been identified. I don't have to say there was a breach of any obligation. And if I've been understood...
You say Clause 8 identifies the agency?
Yes.
Identifies the function, not
the function.
It identifies the function, and you then look and see who's performing it.
Yes. I don't need to go to breach at all. Exactly.
And is it the same person who procured the arrest?
Yes. Or procured the arrest, or whose act, omission, or default occasioned the arrest.
So 8's concerned with function, 49's concerned with arrest, and there's no room or need for any breach.
Neither of them is...
The paragraphs we just looked at.
Yes, exactly.
Are all you really need, and that's the end of it, really.
Suppose that the
That's it. Yep.
Suppose that the position had been that Transclear arrested the vessel for reasons totally unconnected with the chartered service. Let's suppose that they had a claim to ownership of the vessel, I mean, it's rather a far-fetched proposition in the facts, but let's just use it for the moment to test the proposition. Suppose that they had a right to arrest the vessel arising out of something unconnected with the chartered service, like a proprietary claim or mortgage. Would that affect your analysis or not? In other words, they were basically arresting it in a different capacity.
I would say it doesn't affect my analysis. I would say the capacity in which they were doing it was so far removed from their capacity as agent.
That effectively they would not be treated as agents.
Correct.
It isn't
just
connected.
be a coincidence.
Mere coincidence,
It
that's
isn't
right.
connected. There's no function connection.
Yes.
That's the point.
Yes, and
you
it's-
need the
it's-
function connection and you need the arrest connection.
No, I see.
There isn't a function connection.
I-
Just happens to be the same person. But
Exactly. I think, if I may, thank Lord Clark for identifying what has been obvious to him, if not to me, that I do not require there to be a breach of any obligation at all.
So what do you get from those paragraphs of the award? What is the function which you're relying on?
The discharge.
the
The discharge of the vessel.
cargo handling at their
Cargo handling at their expense.
Yes, but we know that if they got round to cargo handling, it would have been at their expense. What I'm interested in getting is what these paragraphs show in terms of Cargill's responsibility for everyone. Cargill in paragraph 13 is simply reacting to the notice of arrest, not surprisingly telling its own master that he can't breach a court order. But you don't get any more out of this, do you?
My lord, you're talking about Cargill's responsibility. Now, within that, if I may be forgiven, there are a number of different assumptions. I am not talking about vicarious liability for the acts of agents. It's Cargill's responsibility, it's Cargill's duty to pay hire unless relieved. I don't need to say they were responsible in any sense of vicarious liability. And I apprehend that my Lord Mance is thinking that I am saying there's a responsibility. I am not.
What I'm trying to do is, you say, or you assent it to the proposition that these paragraphs identify the function of discharging, and that you look and see who is performing it. But
who has?
Calling the shots. Surely it's what it shows is Cargill calling the shots in relation to the discharge. They wanted the thing to be discharged, but obviously after the vessel had been arrested, they didn't stop discharging.
Yeah, absolutely, my lord. So it's
They were doing that through Transglobe or possibly IGB.
well, clearly they would like it discharged because they'd like to stop paying hire. But that's a slightly different point.
No, actually, it works the other way round. You were saying they'd like it to be discharged because that stops them paying hire. If I may, I'm sorry to be pedantic, but actually, if the vessel had been discharged because there had been no arrest, then they would have carried on paying hire.
But I don't understand this line of argument isn't relevant to your case.
It isn't.
Because you're saying simply, as we said, function plus arrest.
It isn't.
Breach or Cargill's involved or anything is irrelevant.
The mistake I'm making, my lord, is trying to respond to questions sometimes which take me away from the case that I'm trying to develop.
Well, you may perhaps unfairly be accused of multiplying your premises completely unnecessarily.
Your lordship, I think that wouldn't be an unfair accusation, my lord. It would be entirely fair.
Or you might say having them multiplied for you.
Yes. That would probably be unfair as well. It's one of the problems of this case is that the arrest was wrongful, and that generates in an analysis. It's not just a case of saying, well, if it's dealing with rightful arrests, then what breach or what obligation has been breached? Here, it's, well, what happens when there is an arrest for whatever reason? And the example given by my Lord Sumption was an arrest for a completely stupid claim to ownership of the vessel. There is a
sensible claim for.
Sorry?
A sensible claim for.
A sensible
has to
claim.
be the same.
Yes. In analysing how this clause works, it's covering a multitude of situations in what has been a very economical usage of terms. And
if it's arrested as a result, rightly or wrongly, fairly or unfairly, as a result of a function which is within Cargill's functions as described in the Charter Party, then you say it is within the exception to Clause 4.
I do.
And that's the beginning and the end of your
It's
case.
beginning and the end of it. And if I've ventured into breach, that was my mistake as an advocate.
Well, it normally would be a breach, as Lord Sumption points out. It's only because here it was a wrongful arrest.
Yes, I mean, and that is in a sense we've got the paradigm of the difficult case in one sense. In another sense, of course, we've got the paradigm of the very obvious case. But it's the vessel was to discharge.
But if the breach case is the obvious case, then are the questions that Lord Mance is putting to you, do they become relevant? Is it right to say your problems are being unfairly, or unnecessarily multiplied?
The question put by my Lord Mance was, well, take the normal receiver's claim for cargo damage caused by the vessel. Now, it may be that it's caused by the vessel, it may be that it's caused by bad handling, in which case that would be the responsibility, the genuine responsibility of Cargill, albeit adjusted by the New York Produce Interclub Agreement. So you can, there is undoubtedly a lamination, if you like, of cases of breach, which may be superimposed. What this case is concerned with is where you do not have such a breach, but there is an arrest.
What I don't understand is, I mean, if we're focusing on the function, I think the question is how broadly you view function. The only relevant function under the Charter, it might be said to be simply the function of handling the discharge and the loading.
Correct.
Right? That's a physical function, so that one can understand that if arising out of the delegation of that to somebody else, some problem occurred, that would be within Charter's sphere. But here, the actual function or the cause of the problem is the contractual arrangements made for payment of discharge, not due to the physical handling of the discharge, but due to the time at which the discharge takes place and how long it takes place. And it seems to me that is something completely out with the time charter. If you define function broadly enough to include anything connected with discharging, I can understand your case, but I'm not sure that that is...
well, is it caused...
anything to do with the head charter?
It's coming back to breach, my lord. If the cause of the arrest is an act, omission, or default by the person to whom the function
the physical
function of discharge has been contracted.
Even though it's nothing to do with the actual physical act of discharge. It's actually to do with something which has stopped the physical act taking place.
Well, it's got quite a lot to do with discharge if it stops it.
Yes.
I see. Well, except, I mean, I think the point made against you is that the time at which discharging occurs is completely irrelevant under the time charter, except that it's got to occur by the time the vessel is redelivered. You can't redeliver until discharge. And so all these subcontractual arrangements for timing are neither here nor there.
My lord, if one's looking for a breach of an obligation, absolutely right. I totally endorse that. If one is, but I'm not saying there was a breach by Cargill in failing to discharge within a particular period of time. I don't have to, and I don't.
Can one test this by, I mean, you suppose that Cargill had procured the carriage of this cargo for their own account, and they had themselves done all things that IBG did, or Transclear did. One would perhaps, on your argument, say, well, there'd be no doubt in that situation that the proviso to the off-hire clause applied.
Indeed. Cargill will be arresting the vessel for Cargill's default. I mean, that was...
default wouldn't enter into it.
No.
I think we've established it doesn't matter why they arrested the vessel.
No.
But if they arrested the vessel, one would have no difficulty in applying the proviso.
Correct.
Your submission, as I understand it, it is no different if instead of shipping it for their own account, they go through a great chain of contracts which causes the goods to be shipped for someone else's account, and they are the people who have the same, who discharge, whose performance under other contracts discharges the Cargill obligation under Clause 8.
Yes.
And therefore they're in no different position than if Cargill had owned the cargo throughout and done something that delayed the discharge.
Indeed. By an arrest or a detention. You're absolutely right, my lord. And that is, as my Lord Clerk has summarised, and as your lordship has just summarised, that is my case. And the error that my learned friend's argument falls into is to associate it with a breach by somebody of a charter party obligation, and I hope that has been dispelled. I do not need to do that.
But it would also be consistent with your argument, I don't know whether you say this or not, to say that the particular test espoused by the Court of Appeal was wider than you need and arguably too wide.
It's one of the... The answer to... It is wider probably than I need, my lord, yes. I mean, one of the problems with my learned friend's argument is that he accepts that agent does not mean agency in the strict contract of agency way. He accepts that it goes beyond that. In a sense, the question then is, how do you apply the limits? Where are the breaks of that expansion of the term? He has to put it as being in the course of performing. I just say within the scope of would be, or in connection with.
In the course of performing an obligation.
An obligation. And
so you escape, you instead of looking at the function as a source of, as a means of identifying who the agents are, you say it's implicit in his submission that there has to be a breach somewhere around.
Exactly. And so...
how do you put it? You said the contrast. He has to say in the course of performing an obligation. How do you put it? Just
I say it is within the scope of, or indeed in connection with, the performance of a function undertaken by Cargill. It's he absolutely requires the very limiting prepositional phrase "in the course of performing," because it's the only way that he can argue that non-discharge during the period of time when the vessel was sitting out at the anchor can possibly generate an arrest which falls outside the proviso. But I say you do not need such a limited prepositional phrase.
What about his point based on the use of the word agent in the two provisions he took us to?
Well, perhaps, my lord, can I take your lordship to the Charter Party? He rather gamely referred to all of the other provisions in the Charter Party, but it's when one looks at all of the other provisions...
What's your essential point, that agent is used in different ways in different clauses?
It's used in different ways, but it's largely used so as to incorporate the people who have, by one means or another, by one form of subcontract or another, been engaged to perform a function.
Well, he's taken us to, I suspect, perfectly properly, what are his two best? What are your two best?
Well, I've got so many.
Well, then you've got...
Could I give your lordships... Yes, can I give your lordships some line numbers?
Yes.
It's 63... 134...
Charter is over there, agent shall direct,
yeah.
I see. 130.
134, 148, 153, 170. I would fully accept that 182 doesn't fit into that. Right. I would then say 224, and I'll take your lordship back to those, and then I think we then get to clauses 49 and 50 and 59. So it is absolutely right, there is no consistent use, but what one does see is the concept of essentially the cargo interests who are going to be doing the shipping, who are going to be presenting bills of lading, who are going to be effecting discharge, are all brought within the ambit of the term agent, except in one or two occasions when it's clearly more limited. But you don't, I would...
Clause 50 would be another...
You mentioned clause 50. Yeah. You mentioned clause 50.
Yes. And clause 50, actually, one does... The smuggling... I've set it out in my written case, so I don't need perhaps to investigate it. But it's the more one reflects upon it, the harder it gets. It was a point which I raised somewhat diffidently, and Lady Justice Gloucester picked up the gauntlet that I had dropped. But the more one reflects upon the agents, you realise it cannot be limited, as my learned friend says.
Well, it obviously is in clause 50. I mean... hard to imagine a situation where a delay or expense or fine could be incurred by the ship for anything other than the behaviour of either the ship owner himself or the charterer or his agent stricto sensu.
Yeah, well. Actually, if I may respectfully say so, I've given the example in the written case of the stevedore, and strangely, that is one that happens time and time again in real life.
Stevedore doing what?
The stevedore who's engaged in smuggling. It's the stevedores who tuck at one end, they will tuck contraband into a hold, and at the other end they will get it out.
But it's got to be already in the port of discharge then. So the smuggling must have happened at some earlier stage.
Yes, it does. Yes, it's you have stevedores in different places. Yes. It's
rather remote.
It is rather remote, but strangely, as they say, stranger things have happened at sea. In this particular, stranger things have happened in ports.
I feel in my bones, Mr. Young, that this case is not going to turn on the true construction of clause 50.
My lord, I think your bones are, if I may say, pretty spot on there. My lord, I've been going rather less than the breakneck speed I was hoping to. My learned friend, on the meaning of the word agents. The meaning of the word agents, as I say, my learned friend has accepted that it doesn't mean agent strictu sensu, it goes beyond that, and then you've got, in some way, to limit it. Yeah, he cited the Media Lanum and the Good Pal. Can I make a couple of points about both of those cases, and then show your lordship one further case? They were each cases where the charterers or their designated agents had given instructions to the ship which were at odds with the request by the person who was said to be the agent for the purposes of creating the vicarious liability. The charterers had said, discharge the correct quantity in the Good Pal, and the charterers had said, go to a completely different spot for bunkering. So what one had there was instantly somebody who was purporting to be a charterer's agent actually gainsaying what the charterers had specifically ordered. And secondly, both of those cases were concerned with establishing vicarious liability, that there was a positive liability in damages or for the purposes of the operation of the interclub agreement in the case of the Good Pal. I am not concerned with vicarious liability, and I'm not concerned with somebody gainsaying clear instructions. But there is one further authority that I hope in the context of my learned friend's submission that there's somehow a natural meaning of the word agents. It's the crude sky, which is at tab 9, which your lordships might be interested to know is either a sister ship or an associated ship of the Rainy Sky, believe it or not. for purposes of arrest, it's probably only an associated ship. This is a very complex case, factually, but I can reduce it somewhat. It concerned a number of subcontracts. Total to a firm called Cusi, to a firm called Vitol, to Trafigura, and then Trafigura had a charter party with the owners, and it was for lifting crude oil out of Nigeria. I'm only concerned with the passage dealing with the charter party between Trafigura and the owners. And in order to get authority to export crude from Nigeria, the shippers, Total, had to get an approval from a government organisation. They thought they'd got approval from the local representative, and they didn't get authority as they ought to have done. The government of Nigeria took great offence at that and seized the vessel, and she was greatly delayed. Now, so it was a mistake by Total, who were the shippers, but I'm concerned with the charter party at the bottom end of the chain. And if your lordships look at the head note at tab 9, 5 lines down, line beginning the respondent as disponent owners of that vessel, the charter party incorporated the terms of the BP void form. Clause 21 was a force majeure restraint of Prince's clause, stating that any delay arising from restraint of princes shall, provided always that the cause of the delay or delays was not within the reasonable control of charterers or owners or their respective servants or agents, count. And the argument was that just because there was a mistake by Total, it didn't mean that there was an error within the reasonable control of Trafigura. That argument did not succeed, and in a passage which, if I could just ask your lordships to turn to it, in the judgment of Lord Justice Longmore, starting at paragraph 26, which is at page 263, going over to 264, in the interests of time, perhaps, can I just ask your lordship to look at paragraphs 29 and 30. And it's sufficiently long. Can I ask your lordships just to read them to yourselves?
Sorry, 29 and 30.
29 and 30.
So it's the last 7 lines you're interested in.
It's the strict construction with a vengeance and the last 7 lines. But you've got to see.
Yes, I see. Yep.
It's
This is the rejection of Mr. Rainey's submission, or possible one of his submissions, that agents means people directly in relationship with you and doesn't include potentially people further down the chain.
yes,
Yep.
and
Yeah, I see.
But it's also making the point that the relevant factor is that they created the occasion for the problem by contracting downstream.
yes.
I question whether that particular point is right, but I'm not sure that it affects your essential argument.
It isn't, my lord. What I rely upon it for is whenever my learned friend uses the term the natural meaning of the word agents.
Okay.
The natural meaning of the word agents is somebody who is employed by a contract of agency.
But this is all in the context of a requirement to have an official loading clearance from whoever the DPR are. And one can understand, I mean, that's something that either you do yourself or someone down the chain does.
Well, you might say the same about discharging a lien for demurrage. It's just a precondition for effecting, in that case, loading, but it could equally well be discharged.
But the argument you've been advancing so far this afternoon doesn't really challenge the meaning of agents, does it?
It doesn't.
Your point on the meaning of agent is once you accept it goes wider than the normal meaning. There's no particular reason to stop where you say Mr. Raymond stopped.
Absolutely. Yeah. Indeed, there's every reason not to.
Where did you say it was the? You said that. Yes, I mean, when you were referring to discharging a lien, you're referring to clause 18 there.
No, I'm not. No, it was a lien under Nigerian law, a lien for demurrage.
Yeah.
I'm sorry. No, it's got nothing to do with the lien. It was Transclear had a lien for demurrage, which they sought to enforce by the arrest of the cargo, which embraced the ship as well.
Yep.
Yeah. Well, so you're not suggesting that the charterers, Cargill, had any obligation to discharge that lien?
Absolutely not.
No, I thought you were for a moment.
No. It was it's the Nigerian lien rather than the clause 18. My lord. On the subject of clause 18, when we've got the authorities bundle open, my learned friend said, well, nobody's ever said that clause 18 means what Young says it means. See the Vestland and the Jalaguri. Can I just show your lordships the Vestland? Because it doesn't really... It's in tab 25, my lord.
Yep.
Actually, neither of these cases actually helps, my learned friend. It was a case which I'll perhaps let your lordships read the head note, but it was a case involving the carriage of slag to Antwerp, which was then offloaded and taken to West Hartlepool, where it was contaminated, and the vessel was sometime later arrested in, I think it was Canada.
Yeah.
And the issue was whether the owners were in repudiation by requiring the charterers to put up security for what their agents had perpetrated by way of redirecting the vessel to Antwerp and then West Hartlepool. Right. Your lordships will see that the facts are a tad more complicated, but it was about whether the owners were themselves in repudiation by requiring the charterers to put up security. And there were two paragraphs in the award which were critical. Can I ask you to lordships to look at, firstly, page 431, para 12, para F12.
Yeah.
The slag was contaminated when stored on the quay at Antwerp. The charterers admitted that the deviation to Antwerp and the discharge of the slag was carried out on their orders, and so admitted the slag had not been damaged whilst on board the Vestland. The damage was not caused by circumstances falling in clause 12 A, B, C of the time charter. And then I show your lordship that. Because it's one of the two paragraphs noted. And the other is page 434, at the top of the page, paragraph 4, which is H4.
Yes.
The cargo damage and the consequent arrest was caused as a direct result of the charterer's orders and of acts committed by the charterer's agents, and known to be so caused at the time of the second arrest. Yeah. Now, Mr. Justice McCatter held that the owners were not in breach in repudiation by requiring the charterers to put up security. But the only passage that's relevant is 182, not quite the penultimate sentence, penultimate paragraph, the second complete paragraph on the right-hand column, as regards the phrase. And this is all that Mr. Justice McCatter says. As regards the phrase incurred by them or their agents, I accept the submission of Mr. Hobhouse, which derives some support from the OED, that these words mean caused by or arising from the acts of the charterers or their agents, or putting it slightly differently, lien or encumbrance which the charterers or their agents have caused to be incurred. There is no doubt on the findings of the arbitrators in paras F12 and H4, the latter of which I set out verbatim earlier, that the liability to arrest arose from the orders given by the charterers to go to Antwerp and of the facts, the acts of their agents there. So it just didn't arise.
Yeah.
And my learned friend also referred to the Jalaguri, which is also particularly unhelpful in this regard. It's the Jalaguri of Mr. Justice Ricks is at tab 16. Now, that was a case which was dependent upon one clause, or critically one clause, which is clause 72, which is set out in the left-hand column of the headnote. Should the vessel be detained or threaten to be detained at any port or place by reason of arrest or any other reason during the currency of the said charter party, the owner shall provide security to release the vessel or prevent such detention under any circumstances. So it's an absolute obligation to relieve. Now, what happened there was that the port authority receiving damaged cargo, which had been damaged by a breach of contract by the owners, insisted that the charterers provide security for the costs of removing the cargo from the port, or from the wharf at least, acts post-discharge. Now, it may be said that they were undoubtedly just acts which were within the charterer's realm, but the case was critically decided by the meaning of the word detained. And if the vessel was detained by that port or order, then that was enough. There was an obligation to provide the security. So it was decided on clause 72.
Right.
But what Mr. Justice Ricks said about the clause 18 is at page 909.
Second column of 909.
Well, just the first column as well, I would submit. The bottom of the first column, it would be very odd if the charterer's liability for that interference.
Oh, I see, yes.
Under the standard form, therefore, the charterers are responsible for arrests caused by them, but not otherwise. Take these considerations seem to me to support my view that the charterers are not responsible under clause 8 for the consequences of seizure by the authorities where the interference has been caused by the owner's breach. So actually, what you don't get in either the Vestland or the Jalaguri is any view of clause 18, which in any way...
Similar to Lord Sumption's example of the mortgage claim by a mortgagee. It's nothing to do with the charterer or the charterer's successors.
That would be right, yes.
I see.
And so my submission is that clause 18 does indeed mirror clause 49 or vice versa. And one is just looking at the functions undertaken and however they may be sought to be performed by or at the behest of or upon the subcontracts from Cargill. And I hope that puts agents into its proper context. I've made some submissions in my written submissions about how act, omission, or default means something different according to whether you're talking about Cargill or the agents, depending if my learned friend is right. In my submission, if my submission is right, act, omission, or default have precisely the same meaning in relation to both. And his difficulty is really concerned with the situation where the arrest is by a third party, probably most commonly by a bunker supplier, but it could be anybody. I mean, bunker suppliers are just the flavour of the month at the moment. But the arrest, if it's by a third party, just with a claim based upon an act, omission, or default of Cargill, or against the agent, each of them is looking for acts, omissions, or defaults which may or may not have anything to do with the actual charter chain, save that it's the presence of the agent, or Cargill, which generates the connection with the vessel, which then causes her to be arrested. And as soon as one contemplates how act, omission, or default does mean different things, as in my learned friend's example, my learned friend's submission, it must do, then in my submission, it actually points rather strongly to the submission that the Court of Appeal was fundamentally right. If I were to be pressed as to whether the Court of Appeal went further than they needed to, yes, I would accept they do, but not materially further. My lords, the context, the charter party context, the commercial context, the purpose of the clause, I've set out in my case how I hope, as it were, what I've taken from Lord Hobhouse in The Hill Harmony, the comment that the time charter has the economic function of the operation of the vessel, and it's how the appropriate indemnities develop. Sorry. How the appropriate indemnities arise according to the use. And I don't actually think that I can improve orally upon the submissions that I've set out in my case.
Whistler, Hill Harmony, yeah.
On that, it's
Page 4, page
16. Indeed. Unless there is anything that I can assist on that. I should have mentioned one point, which I'm afraid when my learned friend has in page 65 set out 3 principles which he derives from the cases, I should briefly give my commentary on those. 51.1, I quite agree.
How long do you think you're going to be?
I think I'm probably got another 5 minutes, my lord. If that's, I'm anxious not to.
We're anxious to finish today if we can, but not to sell your clients.
Well, I'm most anxious not to sell my. I'm here to perform a function, not to perform a function quickly, if I may coin a phrase.
Well, if 5 minutes is fine.
Thank you, my lord. Paragraph 51. Third party in question only becomes an agent or delegate of the charterer by reason of the delegation of an identifiable charter party obligation on the part of the charterer. If I take out the word obligation, I put function to embrace operations which may be, point made by Lord Sumption, about rights, obligations and other things. It's put function. The third party is only the agent or delegate when it is undertaking the performance of, I say that is at best léger de mots for...
Is what?
Léger de mots.
Léger de mots.
Léger de bouche, yes.
Yes. It's embracing a very specific time-related obligation or time-related function when actually what one is looking for is simply a material connection. So it's a question of precision of formulation that I take issue with, but I do not accept that it is undertaking.
Yes.
And the Charter is responsible for acts or omissions of the third party in any wider sense, whether vicariously or otherwise. I'm not trying to say there is any vicarious liability. All I'm saying is that the clause in this contract, which flicks the on or off hire button, switch, operates. My lord, as for issue 2, yes. In a sense, I think I've already covered it.
They seem to be very closely connected.
They are.
I have little difficulty in seeing at the moment how either of you could lose on one without losing on the other. Two go hand in hand.
My lord, my learned friend did at one stage suggest that we had the issues argued separately, and I had exactly the same problem as your lordship's having.
Well, it may be that this is wrong, but that I have to say it.
One of the things I'd ask your lordship to do is to stand back from my learned friend's submissions and just ask whether, if when the parties were sitting down negotiating the contract and the officious bystander had emerged, how he would have been suppressed if he'd suggested that the vessel was off hire. I've introduced the officious bystander because I think in qualification 1 in Arnold and Britton, my Lord said, well, the parties were concentrating on the issue when they agreed the wording. I would respectfully submit that the parties here agreed this wording, which is a very common wording, embracing a very common understanding in charter parties, and they would have been appalled if it had been suggested.
I expect they just got it off the shelf.
Well, you're probably right, my lord. And what's interestingly, my learned friend has shown you the 2015 NYPE Charter, which, in my respectful submission, merely is those who have been the committee looking at the Charter have seen that, well, there might be a dispute about the global Santosh. So let's make the position absolutely clear, shall we? And that's what they've done. I hope, in the space of time available, I have made my submissions clear. I hope I've at least escaped from the breach problem.
Like Mr. Rainey, you've made your submissions very efficiently within the time. Thank you.
I'm obliged, my lord.
Ms. McCrae. Mr. Rainey.
My lord, may I ask how long I've got? out of the interest of my clients, I don't want to have to...
I haven't discussed it with my colleagues, but I'd thought a quarter of an hour would probably be suffice, wouldn't it?
I'll try to do it in that time, my lord. My lord, the question really has narrowed down in the appeal quite considerably. The starting point was the Court of Appeal's decision with its very wide definition of delegates flowing from subletting, which were not to be regarded as akin to agents entrusted with the performance of a charter party obligation. That appears not to be resolutely defended, if I can put it in that way. The question now is, what gives rise to an agency for the purposes of answering the question, who is an agent? And my lord, we would submit that the answer to that question is, and again, the ground appears to have narrowed between us, the performance of the charter party obligation. The question which my Lord Sumption posed to my learned friend as to vicarious performance of a right or vicarious performance of an obligation does not duck that particular question. And it doesn't duck the question if one transposes the word function to include obligation and right. One is still looking at a factual situation which puts a third party in the shoes of the charterer to be treated as his agent. And the only candidate for the function, if one wants to redefine it as function, in this case, is Clause 8 of the Charter Party. So the starting point in the analysis must be, what is the function which is comprised within Clause 8, which when somebody does it for the charterer, makes that person the agent of the charterer, because the charterer is doing that function under Clause 8 through the agency of that person. And it's therefore, in our submission, important to focus on the true nature of the obligation, and if one wants to paraphrase it by saying the function under Clause 8, so be it. But the position does not change. One is still sent back to the wording of Clause 8 and the precise obligation or set of rights bound up with the obligation which are comprised within Clause 8. Clause 8 is confined to the physical carrying out of a discharge operation and bearing the costs of that physical exercise. It is to be contrasted with the position under a voyage charter party where the charterer actually undertakes the obligation to discharge and to do so promptly. Under Clause 8, the only obligation is when discharge falls to be performed, the charterer will put his men on board and pay for that to be carried out. So, my lord, in our submission, when one focuses on the obligation and contrasts the case of the good pal, which is a case of time charter party obligation, and the case of the ANDRA, which is an entirely different set of facts concerned with the voyage charter party obligation, where the obligation was to discharge, the difference between the two cases is very clear. And, my Lord, it doesn't alter in our submission by calling it a function. One still is sent back to the act or performance of the obligation which the third party is doing, because it is only when the third party is acting in the place of the charterer, or the charterer is acting through the agency of that person, that that person becomes an agent at all. And so, my Lord, what one has to do is to have that very closely in mind. My learned friend said, well, that is narrowing the matter, because you're looking at it in the course of the performance of the obligation. But, my Lord, if it is only the performance of the obligation, the carrying out, the stepping into the shoes of the charterer for the purposes of the obligation that gives rise to the de facto agency, which is established in the cases, the Good Pal, the Mediolanum, and the Adelpha, then it is only when that obligation is being performed that the status of the agent is conferred. And, my Lord, one can test it in this way. My learned friend accepted, as he put it in his words, the agency is exhausted by the completion of the carrying out of the discharge operation. So we know when the status of the third party, wholly unconnected with the charterer as agent, comes to an end. So the question then is, when does the status of the third party as an agent, by reason of performing the charter party obligations, begin? Because it can only be in our submission when he actually starts to perform the charter party obligation in question here, to physically start to carry out the cargo handling operation, that he becomes the agent of the charterer. And therefore, one of the points which will be very important for this court in defining the term agent, their agents means, will be, well, we know when the status of agency de facto ends, because it is apparently common ground that it is upon completion of the discharge.
Yes.
When does it begin?
Yes, City.
And that, my Lord, is a question upon which the market and the maritime community is going to want some clear definition. Because it is not enough, my Lord, to say, well, it's, I think one formulation was, within the scope of, or in connection with, or in relation to the function. That, my Lord, presupposes a stage before the function is actually being performed, i.e., when the function is not being performed and when the third party is not doing anything in relation to the charter party obligation because he's not actually performing it. And so the arbitrators who rejected the case, having set out the facts which my Lord Clerk took my learned friend to, had that very well in mind. And perhaps we can just go back to the award in the core volume in the appendix.
Which page do you want us to go to?
My Lord, it's page 141.
Yes.
I'm using the MS.
Yes, indeed.
Numbering.
Paragraph.
No, it starts, I think my Lord Clerk started at paragraph 9.
Well, that's obviously the place to start then.
And so, my Lord, the question one's asking is, when does this agency start, and what is starting it?
Understand.
My Lord, under paragraph 9, the vessel is instructed to remain at the anchorage.
Yes.
Well, there the charterers are performing their own obligation of giving voyage orders. The vessel then proceeds to berth. She's turned away by the port authority and is ordered to return to the town anchorage. How has the agency of IBG or Transclear at this stage been engaged?
I think the suggestion is it's been engaged by the fact that they contracted with them to perform this particular function of discharging.
Well, my Lord, Cargill did not contract with them.
No, but they were...
We do not know that Transclear actually undertook an obligation to discharge at all. The arbitrators held there was no evidence that they were engaged in the discharge of the cargo, and we do not know, for good or ill, the precise nature of the contracts. IBG were not engaged by Cargill to do anything. IBG only stand, and Transclear, would only stand in a relationship to Cargill when they do something for Cargill under the charter party, and the only thing the only obligation which it is being argued they did for the charterers under the Charter Party, which confers upon them the status of agent, is the Clause 8 obligation. There is no antecedent obligation wrapped up in Clause 8 to do things preparatory to loading or discharge, which permits the discharge to be carried out. That is precisely the same argument that was rejected by the Court of Appeal in the Jalaguri, where it was said, well, discharge is your obligation. Surely, therefore, any conditions precedent to discharge are also your obligation. Held by the Court of Appeal, no. Because the sole nature of the obligation under the Time Charter Party, which is very limited, is simply the execution of the physical process and the bearing of the costs.
On this footing, a failure to perform discharge can never be attributed via Article 49 to Cargill. Cargill can never be said to have vicariously failed to discharge by virtue of the inaction of somebody further down the contractual chain.
My Lord, because, my Lord...
that proposition is implicit in your submissions.
My Lord, it's an implicit under a Time Charter Party, because under a Time Charter Party, the Time Charter is not obliged to discharge. So the Time Charter can simply sit there with his vessel on Time Charter, paying hire, absent any relevant off-hire provisions, and there is no obligation. The fallacy, my Lord, in the Respondent's argument is to conflate cases like the Andra and the Good Pal and say, well, it's all in connection with discharge, and therefore it's in connection with the function. Therefore, even though the function has yet to begin, and indeed may never begin, because, say, the cargo is diverted somewhere else, but the vessel is arrested by IBG on precisely these facts, but afterwards Transclear decide to divert the cargo to another party. On my learned friend's case, IBG, although they never come into contact with the performance of the obligation, would still be the agents of the charterers because they were in connection with or in the scope of the intended discharge obligation. That cannot be right. There has to be an ascertainable starting point for the creation of the agency, and one does not create an agency by saying, in the future, you will be doing a task which constitutes the discharge of the fulfilment of the discharge obligation under the Charter Party. Before you come to do that, there are other matters under other contracts which you have to perform. Well, because they're sort of incidental to discharge of the cargo, then I'm going to treat those as performance of the Charter Party obligation as well, and you will become an agent before you actually begin to perform the Charter Party obligation. There is considerable vagueness, as there was in the Court of Appeal, on when and how this agency status is created. And if the court is to assist the maritime community in understanding how this phrase is going to be interpreted, not just in Clause 49, but in Clause 18, Clause 50, and all of the other clauses in the Charter Party, one has to have some clarity as to when the agency is created and by what it is created. The cases before this case were absolutely plain that the agency is created by the performance of the obligation, no more, no less.
Your case is that this is 2 months demurrage, which arises between two people who are in no way connected with a Charter Party function at all.
Absolutely. It has
It
absolutely.
arises entirely independently of the Charter Party because they've got a sale contract which says, they might have said, we'll pay demurrage if the ship spends more than 10 days sailing from Sweden to Nigeria.
My Lord, yes.
Would that have had anything to do with demurrage?
No.
The answer is it would just have been a sale contract obligation.
Absolutely, my Lord. So the appellants have no problem at all with the word function, but it mustn't be allowed to obscure what the test is for creating the agency and identifying when the agency ends and identifying what it is, what is the factum that creates the de facto agency. And my Lord, really the point is as short as that. My Lord, the crude sky does not assist one way or the other because the argument there, which I was advancing, unfortunately unsuccessfully, was that the word agents was to be construed only as agents stricto sensu, so the court didn't really need to get into it. But my Lord, the case of the Good Pal is important and sets out in our submission very telling guidance on where agency is created and where it ends.
Well, you've taken us to that. Yeah.
And I've taken you to that. My Lord, can I just double check that I haven't said anything else? Oh, yeah. Yes. That's why we... Yeah. My Lord, in relation to the Clause 18 point and the arrest mirror provision about the charters having to set aside arrests, which would be plainly very important, the court will need to balance both of those provisions out when it's considering Clause 49. The only point we were making in relation to the Vestland and the Jalaguri was that those are the only cases which have ever considered Clause 18, and that there has been no suggestion over 50, 60, or however many years it is, since the NYP form came in that form, longer than that, that Clause 18 applies to people other than agents as we have defined them.
Mr. Rennie, if you're right, what order do you seek?
My Lord, we seek an order reversing the decision of the Court of Appeal, and because we are right on issues 1 and issues 2, it's accepted that there will be no remission to the arbitrators.
Right.
And if we uphold the Court of Appeal, then the order they make stands.
Yes, if the court finds
Yes,
for me on construction,
quite.
but regards issue 2 as too difficult because of factual issues or whatever, then the order would be remission to the arbitrators, allowing the appeal on ground 1 and remitting.
I'll ask Mr. Young what his view is on that, but of course you're not completely tied, because once we've given our decision, you can agree an order, and if you can't agree it, we can consider it.
We can certainly come back and make further submissions, yes, my Lord.
In writing, yes.
In writing, my Lord, yes. My Lord, unless I can help the court further.
Thank you very much indeed. Mr. Young, disposition, as I say, anything you say is not final, but do you have any quarrel with the summary, Mr.
No, if the appeal fails on issue 1 or issue 2, both, then we carry on and get it remitted to what will now be the new tribunal.
Yes.
And what are they deciding?
They're deciding the issue of causation, the factual issue, whether...
Point left open by Mr. Justice Field, yep.
That's right, which the Court of Appeal said was within his discretion.
Yep.
And they said it was an issue of fact, and which it didn't seem to me there was any question of general public importance that really should take up your lordships with that. So
This is being remitted to Mr. Justice Field or to the arbitrators?
no, to the arbitrators.
New
But we've now that Mr.
new arbitrators.
Now that
That's
Mr. Liftakis has died, we'll get another one appointed. But it's got to go back to them anyway. So I say yes, it does have to go back to them anyway.
Very well, as I say, if anyone has second thoughts or we do something nobody expects, you'll have the opportunity to...
I'm much obliged, my lord, for that. Can I just apologise for having been somewhat chaotic in my submissions, but deciding that I was going to try and answer the questions, I think I departed from my script, which might have made it more sense.
Mr. Young, you were given put a lot of questions during your submissions. I was actually going to say, on behalf of us all, we thought it was very well argued on both sides.
Well,
so thank you both very much indeed. And thank you very much to all those who were involved in preparing the written cases too. We will consider this matter and let you know in due course. Thank you very much indeed. The court's now adjourned.